Hello, I'm Lisa Morse. I am a former CMH employee of 30 years, and I have been doing this BoardWorks sessions for several years now. I am a licensed attorney, so this is an area that I am familiar with. And today's session is Leadership Legal. And as an overview, I'm going to cover some parts of the Mental Health Code. We're going to talk about the contractual arrangement that a CMH has with the department. We're going to spend a little time in the Open Meetings Act, the Freedom of Information Act, and I will mention some other areas that board members may be interested in. So first, starting with the Mental Health Code. It is a set of statutes that are part of Michigan compiled laws, and it spells out the duties and responsibilities of a CMH, among some other things, as well as recipient rights and dispute resolution. And a couple of things I want to say about the code before I go on are, there's a general tenet out there that if you are a private business or a private agency, you can do pretty much anything you want so long as the law doesn't disallow it. The opposite is true for public entities. Public entities, for the most part, can't do anything unless the law gives them permission. And so that's why we have the Mental Health Code. The code's divided up into chapters. Chapter 1 is about the department. It probably still reads Department of Mental Health or Department of Community Health, which now has a new name, the Michigan Department of Health and Human Services. But Chapter 1 speaks to the department's duties. Chapter 2 speaks to community mental health service program responsibilities, and I will be spending most of my time on that chapter. Chapter 3 is about the county of financial responsibility. Chapter 4 and 4A are about involuntary hospitalization for individuals that are mentally ill. Chapter 5 is about involuntary hospitalization for individuals that are developmentally disabled. Chapter 6 is about guardianship. Chapter 7, and also a very important chapter, is about recipient rights. 7A is about the dispute resolution. Chapter 8 is about an individual's financial liability for services and how a CMH determines an ability to pay. Chapter 9 is a miscellaneous chapter, and Chapter 10 is about criminal provisions. But our focus is mostly going to be on Chapter 2 because that is the chapter about community mental health. Chapter 2 of the code governs the establishment, the organization, and duties of a community mental health service program. It details how a CMH is formed or if they merge, because you can be a CMH agency or an organization or a CMH authority, and you'll see that spelled out in that chapter. The purposes of a CMH are outlined in this chapter as well because, as I said, a public entity generally can't do anything unless the law gives it permission, and this is where CMH is told what it's supposed to do. And it says that a CMH services program is to provide an array of mental health services, and then it spells those services out. Now, an interesting point here, when you think about the funding that a mental health program gets, 90% plus is Medicaid money. The rest is other sources or mostly general fund money. If you look at the services a CMH provides under the Medicaid provider manual, the services are called different things. They're not the same as the words that are used in the code. So sometimes there's a challenge of matching those up. But we will go through the array of the things that a CMH does have to provide. One is crisis stabilization. That's a response that has to be available 24 hours a day, 7 days a week. Another service that the CMH has to provide is identification, assessment, and diagnosis. You may hear it referred to as screening and intake. It's where a variety of professional assessments could be done. Also, another service is planning, linking, coordinating. And those should be terms that are familiar to you that sound a little like case management or supports coordination. The next service is specialized mental health recipient training, treatment, and support. It's kind of a mouthful, and it should be, because it really kind of involves all the other services, whether it's individual therapy, group therapy, skill building, a variety of other services. It would all fall under that category. Also, recipient rights services have to be provided, mental health advocacy, and prevention activities as well. Not all of those last services, recipient rights, mental health advocacy, and prevention, are necessarily paid for by Medicaid, but they do still have to be provided. So, moving on to how a CMH prioritizes providing that array of services. The code directs that services have to be provided to individuals who have a serious mental illness, an emotional disturbance, or a developmental disability. And priority can be given to those suffering the most severe forms of mental illness, emotional disturbance, or developmental disability, and then to those who are in urgent or emergency situations. So what can happen, and what's important about this, is if one of the services provided is not a Medicaid service, then it's likely going to be paid for with general fund dollars. And if a CMH doesn't have enough general fund dollars, what it then has to do is prioritize who gets the services. So what ends up happening is there are times when perhaps only crisis intervention or hospitalization can be paid for. So that's important to note. Also, services cannot be denied to an individual because of their inability to pay for services. So in that sense, CMH is kind of the safety net for individuals who are indigent. So I've talked up to now about services that are directed to individuals, but there are other services outside of the offices of community mental health that the code requires a CMH to provide. CMHs are to provide services that are directed to divert individuals from jail, hence we call it jail diversion. They're also required to provide pre- and post-release plans for individuals that need community placement, usually from a state facility, possibly from the forensic center. And they also have to make sure when they're doing that pre- and post-release placement that they are involving the individual, their legal guardian, any other advocate the recipient chooses. Okay, now we're going to move on to board composition. The Mental Health Code also outlines how a CMH board is created. There has to be 12 members. If there is a single county CMH, all the representatives have to be from that county. If it's a multiple county CMH, the board membership has to be proportional to the county populations. And then there are special rules for a single county CMH that includes a large city of more than 500,000, and in our case, that would only be Detroit. Aside from the numbers, board composition also has to be representative of the community, and it needs to be somewhat diverse. The code requires that there be providers of mental health services. Primary consumers is the term that's used as well. Those are individuals that actually have received mental health services. They want to see agencies and occupations that have working involvement with mental health, as well as members of the general public. So they're looking for diversity. They're also looking for the involvement of the individuals a CMH serves. So at least 1/3 of the membership has to be what's called a primary consumer or family member of a primary consumer. And of that third, at least half of those members shall have to be primary consumers. There's not always a way to determine that that has been followed, because generally a person who has received services doesn't have to tell you that. So oftentimes CMHs will have board members self-report and rely on that self-report to ensure the membership composition is the way it should be. Additionally, all members have to be 18 years of age or older. Board terms are generally 3 years. Of course, someone could always come on and fill an unfulfilled term or leave sooner, but generally they're 3 terms. And board members can also be paid a per diem and mileage. Again, we're back to that notion of a government entity can't do anything unless the code gives them permission to. So the code does allow for board members to be paid and to get reimbursed for mileage. Now, a thing about the per diem is there's different schools of thought on how that should work. Per diem, by definition, means per day. So if a board member has 2 meetings in one day, he or she does not get 2 per diems. They get 1. I don't think that that's consistently implemented, but that is how it's supposed to work. Additionally, there is also some different thoughts about the amount of a per diem. Some schools of thought say that the per diem cannot be any more than the County Board of Commissioners would pay for one of its meetings or committees. So there is a variation out there. So moving on to CMH board responsibilities, and this is where you should really be aware of these activities that I'm about to talk about, because as board members, you need to make sure that they've been done. One of the things the CMH board has to do is annually conduct a needs assessment and determine what the needs of the residents of your county are, or your area if you're multi-county, and what kinds of services will help fulfill those needs. It's kind of, you may have heard the term gap analysis. Do you have a gap in the services you're providing? That assessment then has to be submitted along with an annual plan and any request for new funds to the department in accordance with the procedures established by the department. The needs assessment has to include information gathered from all appropriate sources, including mental health waiting list data and school districts that are providing special education services. If the CMH is an agency, and I say agency as opposed to an organization or an authority, it is a department of its County Board of Commissioners. So if the CMH is an agency, then the board has to obtain approval of the needs assessment, the annual plan, and its budget and request for new funds from the County Board of Commissioners. If the CMHSP is a non-agency, then it at least has to provide copies of all those materials to the Board of Commissioners. Then part of this process as well is the board must have a public hearing on these documents, the assessment, the annual plan, any request for new funds, so that the public has an opportunity to understand what the plan for the year is, and then the board would submit it to the County Board of Commissioners. The CMH board also has to approve an operating budget each year. They have to submit an annual request for county funds to support their program to County Boards of Commissioners. Now, in that, sometimes that's referred to as county match. There are some instances where a CMH that's become an authority, that's no longer a department of the county, may have that amount frozen, meaning it doesn't increase or decrease. They get the same amount every year, but they still have to request it. The board's also responsible to secure any other kinds of funding that it thinks might be available to it, whether it's grants or other public funds. The CMH board is also responsible for approving and authorizing all contracts for the provision of services. Now, this can actually be done in different ways. Many boards have board policies that say only certain contracts of a certain value have to come to the board for approval, and they will designate their executive director as having the authority to sign other contracts. That's not uncommon. The board also has to review and evaluate the quality, the effectiveness, and the efficiency of its services. Many do that through their quality improvement plan. The board is responsible to appoint an executive director who has to meet certain experience and training standards. And then that executive director has the authority and responsibility for supervising all the other employees. So what that means is the director is the only employee of the board. So the board should not have direct involvement with other employees for any purpose. The community mental health also has to establish general policy guidelines for the director to operate the CMH. The board is a policy board. They should not be getting involved in the day-to-day operations of a CMH. That is for the director to do. The code also speaks to the job of the executive director. The executive director is the chief executive and administrative officer of the program. He or she is responsible for administrating the program in accordance with the annual plan and budget and the policy guidelines that were established by the board. The director also has to appoint a medical director who is a psychiatrist to advise on medical policy and treatment. A new section of the code that I'm going to talk about is one that was established just about 2 years ago that created regional entities. The regional entities were established to manage and implement the Medicaid contracts across the state. So there are 10 entities. And as I know I'm repeating myself, but I think it's important to remember that these entities couldn't exist without this code provision because, again, a public entity can't just do something unless the code authorizes them to do it. So this new section had to be added to show that it was okay for these regional entities to be created. There was a process called an application for participation, or AFP process, that began in 2013. And it reduced the regions from 18 to 10 regional entities. That's all I'm going to cover on the mental health code, and now we'll move on to the contractual arrangements. Generally, the relationship between the Michigan Department of Health and Human Services and a community mental health is that of independent contractors. You may hear the term co-employer being thrown around out there, that the department can't get too involved in what a CMH is doing, or there could be co-employer issues. So it's very important that they maintain the independent contractor relationship. And this is going to be true with the department and the regional entities as well. That no agent or employee or servant of the regional entity or a CMH can be deemed to be an agent or employee or a servant of the state, again, to keep that separation. In the contractual arrangement, the community mental health program is solely and entirely responsible for the obligations in the contract. It doesn't mean that they don't contract out to other providers, but they are the party that's answerable to the department. Any liability or loss or damage as a result of a CMH obligation under the contract has to be the responsibility of the CMH, and the opposite is true for the department. If there's liability or loss that's a result of the department's obligations, then that will be the responsibility of the department. Another specific item as part of the contractual arrangement is that written notification has to be given to the department if there's any pending legal action. That really means pending legal action as it relates to the services of a CMH. So a little more specific about the contractual arrangements. First, we'll talk about the regional entities, and those are called prepaid inpatient health plans, or PIHPs. They are the entity that's responsible for the Medicaid and Healthy Michigan service implementation throughout the state. They have to manage what's called the 1915 B and C waiver programs. And they have to manage the provision of specialty mental health and substance use disorder services and supports. Those services under that Medicaid contract are often referred to as state plan services, B3 services, HSW or habilitation supports waiver services, and the new Healthy Michigan. There is also a My Child component to that contract as well. So as I indicated, the PIHP is responsible for the operation of the 1915 B and C programs, and those numbers come from federal statute. So it's not important that you remember it's 1915B, that's just how they're referred to. The PIHP is responsible to develop a service delivery system. They have to establish sufficient administrative capabilities so that the department knows they can actually implement the contract. They have to comply with all the reporting requirements, and they also have to comply with the Code of Federal Regulations that deals with managed care. You'll see the CMH responsibilities for, as I referenced earlier, the general fund services is very similar. They have to develop a service delivery system. They have to establish that they have sufficient administrative capabilities, and they too have to comply with reporting requirements. A CMH has to agree to meet the priority needs that are reflected in the mental health code. We talked about those before, that they have to serve those that are the most severe. They have to ensure timely access to support and services. They have to report its performance on the standards. It has to locally monitor its performance and take action to improve. And it may use medical necessity criteria. I say may because medical necessity criteria is a Medicaid term. So that's something when implementing or providing Medicaid services that has to be met, but not necessarily if you're providing services that are paid for by general fund. So, moving on to the Open Meetings Act. The Open Meetings Act is an act to require certain meetings of certain public bodies to be open to the public so that the public can personally observe the policymaking process. They want the government to not operate in secret. They want to see transparency. So we have to figure out what those certain meetings and certain public bodies are. So what's a public body? Well, it can be pretty broad. It's any state or local legislative or governmental body. That includes a board, a commission, a committee, a subcommittee, an authority or council empowered by statute, constitution, ordinance, or resolution. And CMHs would fall under that last part as an authority or an entity that's empowered by statute. So now we know what a public body is, but what's a meeting? The convening of a public body at which a quorum, which is more than half, not 51%, that's present for the purpose of deliberating toward and rendering a decision on public policy. Those are all very important terms, deliberating toward and rendering a decision on public policy. If members of a public body constituting at least a quorum convene for the purposes other than deliberating, like an educational session, then it's not a meeting. So I always caution board members to be sure if you're at a conference and several of you go out to dinner together that you don't start doing business because you would not have given proper notice and you'd be in violation of the Open Meetings Act. Meetings have to be posted. The public has to be given notice of all meetings of public bodies. It's the way they know that they can be present to participate. It always has to be posted at the principal office and any other location considered appropriate by the public body. If there is no principal office, then it has to be posted in the office of the county clerk. A public notice has to be posted 10 days after the first meeting of the public body in each calendar year or fiscal year, stating the date, the time, and the location of its regular meetings. Changes in the schedules to regular meetings have to be posted within 3 days after the meeting where the changes were made. Rescheduling regular meetings and special meetings have to be posted at least 18 hours before the meeting. So now what's a decision? A decision is a determination, an action, a vote, or a disposition on a motion, a proposal, a recommendation, a resolution, an order, an ordinance, a bill, or a measure on which a vote by members of a public body are required or by which a public body effectuates or formulates public policy. That is a long list. But the point is they want to be more inclusive than exclusive when we're talking about has a decision been made. A decision also includes deliberation towards that decision. Now, you may have heard of this idea of a closed session because the Open Meetings Act means they want meetings to be open. But there are times when a board can go into closed session. They have to meet in closed session for only 10 reasons. A roll call vote has to be taken to go into closed session, and a motion to go into closed session must include the purpose. It doesn't have to get into the detail, but it has to state the purpose. When is there a violation of the Open Meetings Act? Well, if you don't comply with the provisions, there's going to be a violation. The Attorney General, the county prosecutor of the county in which the public body serves, or an individual can initiate a civil suit to compel compliance or for injunctive relief. A civil action has to be filed within 180 days after the date of the violation. Court costs and actual attorney fees can be awarded if the individual prevails in his or her action. And if it's determined that a public official intentionally violated the act, exemplary damages of not more than $500 may also be awarded. Are there criminal consequences? A public official who intentionally violates the act is guilty of a misdemeanor and can be fined up to $1,000. If the public official is convicted of intentionally violating the act for a second time, the fine is going to be increased to $2,000, and he or she can be imprisoned for up to 1 year or both. So the important thing to remember here is don't violate the Open Meetings Act. And as board members, you are responsible to make sure that those things are followed. Now I'm going to move on to the Freedom of Information Act. This is another set of statutes of the state of Michigan. And it's an act which provides public access to certain public records of public bodies. Here we go again with terms. We have certain public records of public bodies. And as a note, persons that are incarcerated in state or local correctional facilities cannot request information under the Freedom of Information Act. So we're asked the question again, what's a public body? A public body is a state officer, employee, agency, department, division, bureau, board, commission, council, authority, or other body in the executive branch of the state government. Well, that wouldn't be a CMH because we're not in the executive branch. It also can be an agency, board, commission, or council in the legislative branch of state government. Well, that's not a CMH either. But then we start getting broader in the definitions. A public body can be a county, a city, a township, a village, an intercounty, intercity, or regional governing body, a council, school district, special district, or municipal corporation, or a board or department, commission, council, or agency thereof. Well, you could argue that maybe those regional entities fit into that category, but I don't know about a CMH. So we have one last definition, which is any other body which is created by state or local authority or which is primarily funded by or through state and local authority. And a CMH would certainly fall into that category. So we know what a public body is. What about a public record? Well, that is a pretty broad definition as well. A public record is a writing prepared, owned, used, in possession of, or retained by a public body in the performance of an official function. A public record does not include computer software. So we talk a little bit more about this. The record actually has to exist. A CMH doesn't have to produce a document or create a document that includes the information that the requester is asking for. So if you have a report inside of a computer for which all you have to do is press a button and it will produce that report, then that's going to be a public record. But you don't have to go in and design computer software to actually create a report. There are two kinds of those public records, those that are exempt and non-exempt from disclosure. How do you make a Freedom of Information Act request? It must be in writing. In the past, you could do it verbally, but it must be in writing. It can be transmitted by a facsimile or electronic means like an email. It has to sufficiently describe what's wanted to enable the public body to find the public record. Otherwise, the CMH can deny it because it can't figure out what the requester is asking for. And the request has to be directed to what the Community Mental Health would identify as its FOIA, or Freedom of Information Act coordinator. How long does it take to get information? The response by a CMH has to be made within 5 business days after receipt of the request. So you don't have to count the day it comes in, but you'd be surprised how quickly that 5 days can go by. So it's really important that your FOIA coordinators stay on top of those requests. It can't sit in somebody's mailbox or on a secretary's desk. It needs to be processed. The public body can extend the time period for an additional 10 business days, but only one extension is allowed per request. And the notice of this extension has to include the reason and the date that the response will be provided by. That's generally when you have a request for lots of information, and it'll just take more time to pull it all together. So does it cost anything to request information under the Freedom of Information Act? Yes, it can. The public body can charge the actual cost of copying the public records, the cost of mailing the public records, and a fee for collecting all the information. But the fee that's charged cannot be more than the hourly wage of the lowest paid public body employee that's capable of retrieving the information. So, for example, you may have a supervisor collect information, but if a secretary could have done it, and I'm assuming the secretary is paid less than the supervisor, then you can only charge the cost of the secretary wage. The public body can also request a deposit equal to 1/2 of the total charge if it's going to exceed $50. And it can also require a payment by the requester before actually providing the records, meaning you'd exchange them at the same time. So, what's exempt from disclosure? As mentioned before, there's 2 kinds of records, exempt and non-exempt. There are 25 different exemptions from disclosure. The most common are privacy, statutory exemptions, attorney-client privilege, and law enforcement records. What happens if an entity denies a request? If a public body denies a FOIA request in part or in its entirety, the public body must explain why the request is denied and inform the requester of his or her right under the Act. The most common denials are generally due to an inefficient description of the public record being requested and the inability to find the records. What if a public body does not respond to a FOIA request? Well, if a CMH doesn't respond to a request, it's considered a denial. And if denied the requested information, the requester can submit to the head of the public body, like the director or I imagine a board chair, a written appeal that specifically states the word appeal and identifies the reasons that they think the denial should be reversed. Also, the requester can initiate an action in circuit court within 180 days to compel production of the records. Can damages be awarded? Yes, reasonable attorney fees, costs, and disbursements may be awarded if the requester prevails in his or her action. And if the circuit court determines that the public body has arbitrarily or capriciously violated the Act, the court may also assess actual or compensatory damages as well as punitive damages of $500 against the public body. There are other legal areas for board members to consider. There is HIPAA, which is the Health Insurance Portability and Accountability Act. There is the MIP, or the Medicaid Integrity Program. Of course, there is the Elliott-Larsen Civil Rights Act, and a variety of other laws. But today we've covered what I believe to be the most important things for a board member to know. Thank you.